Hey there, Jonathan Ratchik from Kramer, Dunleavy Ratchik. For over 30 years, our firm has been helping injured New Yorkers or New Yorkers who have been injured due to the negligence and wrongdoing of others. And today I'd like to talk about construction accidents. So if you're a construction worker in New York, there are three laws that can completely change what happens after a job site injury. Labor law sections 240, 241.6, and 200. So most workers have heard of them, but few have actually know what to do, who they protect, and why they're so powerful. So today, I'm going to break down for you in plain English what they cover, the types of work involved, the damages you can recover, and the defenses that the other side will try to use to diminish or knock out your claim. Okay. So if you do construction work in New York, or you know someone who does, this is information they need to have. So let's start with the big picture. Construction, it is one of the most dangerous industries in New York. Okay, workers, they are climbing, they're lifting, they're cutting, welding, demolishing, oftentimes at heights, oftentimes with heavy equipment, and almost always under pressure, right? There is never a contractor or subcontractor in the world who is doing the work on time. They're always behind time and under the gun. And New York's legislature, they understood something important, that workers don't control the job site. They don't choose the equipment. They don't design the safety plan. They don't set the pace of the job. The owners and the general contractors do. So these laws, they shift responsibility upward to the people with the power to make the job site safe, the owners and the general contractors. So let's start with the one you probably heard of, Labor Law 240, the Scaffold Law. But despite the nickname, it's not just about scaffolds. Section 240 protects workers from elevation or gravity-related hazards, meaning falls from heights, injuries caused by falling objects. If you're a worker on a ladder, a scaffold, a roof, a hoist, or you're under something that maybe should have been properly secured, 240 is in play. And it applies to all sorts of work: construction work, demolition, repairs, alterations, painting, cleaning, pointing. If you're doing real physical work on a structure, chances are you're covered by Section 240. And under this section of the law, owners and general contractors have to provide proper safety devices, okay? Ladders that don't wobble, scaffolds that are secured, harnesses, lifelines, hoists, pulleys, and they have to make sure that these devices are placed and that they're used correctly. And here's what makes Section 240 so strong. It's what we call strict liability. If there is a violation of the statute and that violation causes an injury, the owner and the general contractor, they are responsible, period. And the workers, your own comparative negligence, meaning if you made a mistake, it's not a defense. Now, that doesn't mean that they're not going to try to get around it, right? They're going to argue that, the recalcitrant worker defense, you refuse to use the safety device we gave you, or the sole proximate cause defense, right? We gave you the right device, you knew how to use it, and you chose not to, and that's the only reason you got hurt. Or perhaps it wasn't an elevation-related risk at all. And these defenses, they're narrow, they're strictly construed, and the courts interpret Section 240 very broadly in favor of injured workers, okay? But they're going to be raised in almost every case. And in the event that Section 240 applies, you can recover all of your damages, okay? If you're injured on the job, a construction worker, they're going to be entitled to workers' compensation benefits. Medical bills are going to get paid, and your lost, or at least a portion of your lost earnings are going to get paid. Nothing for pain and suffering, nothing for your future wages, okay, or your future economic loss. In a third-party action brought under Section 240, you can recover the full extent of your damages: pain and suffering, lost earnings, medical expenses, future economic loss. It is a lot more than a worker can ever recover in a workers' comp case. There's also, and so the next section is what's known as Labor Law Section 241.6. This also applies to construction work, excavation, demolition work, and it requires owners and general contractors to provide a safe place to work and to follow specific industrial code regulations. And that's the key difference that's one of the key differences between 240 and 241.6. It's tied to this industrial code. It is a compilation of state regulations that relate to construction sites and providing a safe place to work, okay? And workers who are bringing claims under this section of the industrial code have to point to a specific concrete violation or concrete regulation that was violated, not a general safety rule, okay? And there are lots of regulations, okay? They can be for missing guardrails, tripping hazards, unsafe flooring, defective power tools, lack of proper protective equipment. But unlike in 240, so whereas 240 is strict liability, 241 is not absolute or strict liability. Okay, you have to prove the violation caused your injury, and your own alleged comparative negligence, it does apply, meaning that the defendant, the owner, or the contractor, they're going to argue that your own negligence, your own comparative fault, either caused or partially contributed, okay, to the incident. But either way, you still get the same full amount of damages that you would be entitled to under Section 240. And lastly, there's labor law Section 200. Okay, this is basically a codification of the common law. It's New York's version, the codification of the common law duty to provide a safe workplace. It applies to all sorts of hazards, not just height-related issues or industrial code violations. Two theories under Labor Law 200. One is the means and method. Okay, did the owner or general contractor supervise or control the work that caused the injury? Okay, that's one theory, okay, that you can hold them responsible. And the other is, did they have either create or did they have notice of the dangerous condition on the job site that caused the worker's accident? Okay, so if you answered yes to either of these questions, Labor Law Section 200 can apply. And again, common defenses that are raised by owners and general contractors in this case are going to be that they didn't supervise the work, they didn't control the means and methods, or they had no notice of the dangerous condition, right? Either they didn't know about it, or maybe it arose moments before the incident occurred. And these are very fact specific, and they change from case to case. But they're defenses that would be raised in any type of common law lawsuit. And again, the damages, you can recover the same types of damages you can in the 240 or 241-6 case: pain and suffering, economic loss, medical expenses, past and future lost earnings. So again, across all three of these statutes, the types of work covered, it's construction work, it's demolition, it's repair work. And these are broadly construed because the purpose of the statute is to protect the workers, okay, not to shield the owners and the general contractors. Routine maintenance or purely decorative work, that's going to fall outside the statute, but these are always very fact-driven, fact-specific cases that are not necessarily subject to a snap judgment or a snap interpretation, okay? But at the bottom line, these laws matter, okay? And they matter because workers' comp benefits are oftentimes, they're never enough. Workers' comp is going to pay medical bills, a portion of your lost earnings, but it will not compensate an injured worker for his or her pain and suffering, future lost earnings, or really the long-term impact that an injury can have on someone's life. And labor law, these statutes hold the parties with the most control over safety, owners and general contractors, accountable, and make them ensure that the workplace that they have control over is safe for people doing work. If you are a construction worker in New York and you've been injured on the job, you might have rights under one or more of these statutes. Don't assume that you are limited to workers' compensation benefits. Don't assume that because the incident may have partially been your fault, that you don't have any recourse. And don't assume that you're not protected. If you have questions, reach out. I'm always happy to talk you through your specific situation and try to understand whether or not we can help you. So Jonathan Ratchik, again, Kramer, Dunleavy Ratchik, experience you expect, commitment you deserve.